SJC-13847 in the matter of an impounded case.
Okay, Attorney Nearing.
May it please the court, my name is Ilsa Nearing, and I represent Doe. How could Doe possibly have had a fair hearing when he only learned in appellate proceedings that the evidence against him was alleged common sense and misconstructions of research? The agency's action violated Doe's due process rights to notice of the evidence against him, an individualized classification grounded in objective facts and data, and judicial review confined to the evidence in the record. In Doe's case, there are two reasons why it was error to apply the number, dates, and nature of prior offenses in the index cluster to Factor 37. The first reason is Factor 37 is a catch-all provision. It is an important safety valve that protects sex offenders' due process right to an individualized classification grounded in objective facts and data. Here, SORB has conceded.
Let me ask you about that. You argue that Factor 37 only goes one way, and it's a safety valve. You can't say where you're getting. I know we've said it's a safety valve, but it says you should take into account any other information on both dangerousness and repetitiveness, right? And rehabilitation. What's the basis to say it only goes one way?
One way towards?
Right, towards us as a safety valve, to help as opposed to hurt an offender.
Because it is for consideration of information that's not already contemplated under those statutory and regulatory factors.
Right, it's a catch-all, but it could go either way, correct?
Yes, and if SORB wants to introduce evidence, first of all, they have to work within the framework, and the framework of due process is that a sex offender is entitled to an individualized classification grounded in objective facts and data, and in addition to that, all agencies' decisions must be supported by substantial evidence.
So part of the evidence that was relevant here to the hearing examiner on this point was the evidence regarding the nature of this offense. And of course, Doe had notice of all of that evidence regarding the victim's testimony that Doe had offended against her multiple times over the course of months. Doe had notice of that information, correct?
Yes, Your Honor.
And I think the court has frequently said that this whole past is prologue idea about that, with respect to dangerousness, and the hearing examiner is supposed to think about how dangerous would this person be if they reoffended, and that they're allowed to take into account the nature of prior offenses. Mm-hmm. So does that fall? The hearing examiner here seems to have put that past as prologue idea under 37 here and said, under 37, I'm going to consider that because in the past this was repeated conduct over a bunch of months, if the offender offended again, it would likely also be, for example, against the child of a person Doe was dating, and would potentially persist for a lengthy period of time, and therefore Doe is more dangerous. Is there a different factor that was supposed to fall under? Because I take it your argument is things that are already covered under other factors shouldn't be lumped under 37. So where should the hearing examiner have taken into account that sort of past as prologue factor, or do you think it was not a proper factor?
So past as prologue goes to the final determination. Is all the evidence which has been established by preponderance when we gather together, does that prove by clear and convincing substantial evidence that this offender's degree of dangerousness as a function of the severity and harm that would occur in the event of reoffense, is that low, moderate, or high? And in this case, first of all, danger increasing factor 3 was applied to the prepubescent victim. So we have that. So we don't need to reapply factor 37 to the prepubescent victim, which is what happened here.
Well, there's sorry, go ahead. No, please go ahead.
Those are two separate things. The prepubescent victim has to do with whether or not they have a sexual deviancy, which is an issue that was raised. But you could offend against a prepubescent victim and also offend against a prepubescent victim in repetitive fashion. That's a different sex offender, correct?
Well, there is no research, there is no substantial evidence of information grounded in objective facts and data that the number, dates, and nature of prior offenses in the index cluster prior to first apprehension increases overall dangerousness. A classification, in order to comport with due process, must be grounded in objective facts and data.
Your argument, as I take it, is that unless there's a Hansen study or some empirical evidence to show this past this prologue dangerousness finding, it's improper for a judge to say, well, it's common sense that if they're repetitive and it happens over a long period of time, they're more dangerous, correct? It's Judge Gordon's finding of common sense that you, in the hearing office, essentially, you take issue with.
Common sense, by definition, is not grounded in special or technical knowledge. Therefore, it's not grounded in objective facts and data. It can't be entered in the record. It's not disclosed to Doe prior to the hearing. What is it? It's just common sense that this repetitive behavior prior to apprehension increases dangerousness. But why and how? We have no understanding. How can a person respond to that? It's never been that way before. Why is it now? Please tell me why.
Sorry, are you done?
I am.
Are you? So we've decided your case except for one issue, which may be a good one for you, and I'd like you to focus on it. Unlike in the case we just did, where we said the legislature has said you should consider the number, we had no information again. Hansen, we had a letter from Hansen, but you did something different in this case that's important. You requested an evidentiary hearing, right? You asked for an expert, you asked for funds for an expert on this particular point, right? I read through the record. I want to make sure I understand the timing of when you did that. But my understanding is, because I think you've got a loser here if you're just going to repeat the case we just decided. But you have a different question, which is you requested money for an expert to prove Hansen's point, which is something we left open in the last case, right? You're looking at me blankly. Maybe I'm misreading what you did, because that to me is by far your best argument.
That the motion for an expert was denied.
You asked for an expert. I read through your request. You said, Hansen's, there's no scientific support. I want an expert to prove that this common sense point is wrong. And you were denied that. To me, that's the only difference between your case and the prior case, and that may be a significant difference because you're asking to try to prove the point you're assuming here. We can't assume Hansen's right, but you have an ability to ask for an expert to do that. That seems to be the issue we left open in the last case, right?
Yes,
I'm throwing
Your
you a
Honor.
softball. If you don't want that softball, just let me know. Yeah.
So in my situation, I didn't know that what was going to be applied to Factor 37 was alleged common sense. That's something that came out in the Superior Court during the 30A review. In my case, I asked for an expert.
It's proved to be what we say, absent proof to the contrary, right? The legislature dictated that number and matters, and you should consider it. Before we disregard that, we need scientific proof that that common sense thought is not correct. We can't just assume it's not correct. And we can't assume it because Hansen wrote a letter on it. We need a science, but you did ask for a hearing, right? You asked for an expert. Again, if I'm misquoting the record, you let me know.
Well, an expert would have been a means to put into the record for judicial review whether there is substantial evidence of information that this behavior prior to first apprehension, if there's a reason to believe that it does increase dangerousness, or reasons to believe it does not. I don't have the answer.
Right. Again, I'm trying to be helpful to you.
Thank
Is it
you.
your position that common sense can never be resorted to? That common sense can never be resorted to? Or is your position that common sense can't be resorted to without notice, that common sense is going to be resorted to? Or is your position that common sense can't be resorted to where we're talking about repetitive behavior before apprehension, pre-apprehension, repetitive behavior? What do you have a position on? Is there any circumstance in which common sense can play a role, or is it your position that just common sense can never be brought into the picture?
First of all, there is nothing in the record that explains from the hearing examiner himself how is this common sense, and that common sense, it has to be written down in the record for judicial review. And common sense is sort of a prudence in managing affairs, and it's not grounded in any special or technical knowledge. So how do we know? And one person's common sense is different from another's. And if it's not in the record, we don't even know what the rationale was. And as for this sort of repetitive
I
behavior,
understand that argument, because I thought the hearing examiner specifically said, referenced them multiple times over several months, and said that that related to Doe's overall dangerousness. Should he reoffend?
so I think if we look at this by analogies, such as the open and gross, lewd, and lascivious cases, these people are repetitively doing the same behavior, but it doesn't increase their dangerousness.
Why do you
Contact
say that,
offenses
though?
versus non-contact offenses.
I beg your pardon?
Those are contact offenses versus non-contact offenses. Open.
Okay, so yes, and in contact offenses, we determine based on certain factors, and it's the violence in the past offending, which is the prologue for dangerousness as a function of the severity and the harm that would occur in the future. So in this case, the only danger increasing factor that we know of was the child victim, factor 3, adult offender with child victim. The other danger increasing factors for the static behavior, if we look at factor 8, it says that all sexual offending is violent. However, it is excessive violence, it is weapons, it is bodily injury, it is threats to bodily injury. We also have factor 19 that increases just it is the penetration. So it is the past violence, which is the future prologue. This offenders did the bare minimum to commit the indecent assault and battery. And it is the actions and the harm itself in the past, not the mere that it too happened in 5 months.
Counsel, may I ask you, what are you looking for in terms of relief?
Well, ideally, I would ask this court to modify and reduce to a level 1, because
I thought so. So with respect to that request for relief, what's the best record evidence, assuming that you didn't want to take the EFIS pitch that Justice Kafka gave you, when it comes to the record evidence, what is the best record evidence that you're relying on to modify his classification to level 1, given that the fact that factor 3 was applied with increased weight, and the victim was 11.
That the case was remanded from the Rule 23 decision because that panel said that it couldn't be said with certainty that once the excision of high risk factor 2 was gone, that one risk and danger high risk factor 3 plus the factors 10 and 13, which had minimal weight ascribed, that was, it could be said with certainty that it was a level 2 classification. If it's determined that factor 37 and the sentence in the preamble were inappropriately applied, then we're back to where we were before. We can't say with substantial certainty, and it's really, really clear that the hearing examiner believed that he needed not only danger increasing factor 37, but the sentence in the preamble to tip this up from a 1 to a 2. Now, I mean, if I was remanded for a new hearing, of course, I would like to have the expert as well. That would be very helpful.
Thank you.
Thank you very much. Attorney Greenaway.
May it please the court. Good morning. Oh, yes. Good morning, Justices. Roxanne Greenaway for the board. In this particular case, the hearing examiner considered the specific facts and circumstances of this case and was guided by not only the publicly available regulatory factors that the board follows, but the definitions, explanation, principles, and authorities cited therein, as well as the sex offender registry law and relevant case law. And in so doing, the hearing examiner looked at the repetitive contact sex offense that took place here with a prepubescent child victim. And I would point out that indecent assault and battery on a child is a sexually violent offense. Now, honing in on the dangerousness aspect, the board is statutorily mandated to decide dangerousness. When you look at the statute, it gives the board the authority to enact these regulations that assess what that dangerousness is. And if you look in 803 CMR 1.20.
Can I just cut to the chase, at least for my purpose,
Sure.
on factor 37, okay?
Yes.
So factor 37 is this catch-all, and I think I agree with your position that it isn't just factors or other information that helps a sex offender. It's also factors that would increase registration numbers. But can a judge use this common sense determination when not supported by empirical data or a Hansen study or something like that?
Yes, there is nothing, and I would actually point the court to Doe 10216, where the court indicates that no expert testimony is required to be presented by the board in proving risk and dangers.
But that's different from a factor that's been normed through, because the board, we defer to the board because the board has expertise in these matters. And having no expert testimony is different from application of a factor that's been proven to be correspond to sexual dangerousness, right? So put aside that the board doesn't have to call an expert.
Mm-hmm.
I'm just wondering whether or not the board can, or a hearing examiner can apply a factor that is just common sense as opposed to have something that's empirically proven.
Well, I think when we look at common sense in this regard, we're looking at the hearing examiners. These are hearing examiners that operate within this rubric of deciding risk and dangerousness to sex offenders across the Commonwealth on a weekly basis. So when you look at a hearing examiner, I believe one of the justices had asked previously, can anyone use common sense? Clearly, the factors do not limit a hearing examiner to just what is listed there, because again, they're guided by other principles. But in so doing, the hearing examiner spells out what it is that they're relying upon in coming to that common sense determination. And here, I often say, when you look at the hearing examiner's evaluation of this particular individual, he spells out over and over again that it's based, the dangerousness aspect on the factor 37 is based on the repetitive conduct. Now, there is nothing in the statute or the regulations or case law that mandate any of these factors to be supported by empirical research. Here, it is.
That's not really true. Some of our cases, the case involving the woman prisoner and also the elderly offender, we've said data may be important in a number of cases, right?
And to address those particular cases, Your Honor, in Doe 151564 and in Doe 205614, those are the age and the female considerations. In those particular cases, it's quite different from this one, because what you have there is you have the offender asking the board to take into consideration research that is beyond what was mentioned.
So that brings me to the question that Justice Kafker was focused on, which is, that's exactly what Doe wanted to do in this case, was give me an expert so that I can bring before you research that might debunk this common sense that you're clinging to on the repetitive in factor 37.
And you don't need an expert to bring forth that research if it exists. If Doe wanted the
Well, it would be helpful to have the expert in the field identify whatever articles he or she might be able to find.
Yeah.
I mean, why would you, that seems
And how,
like not the right test for whether or not an expert funding should be allowed.
Well-
The question is whether the expert might bring something to the table that would be helpful to the hearing examiner and inform the hearing examiner's common sense conclusion. I'm not saying that's wrong, but for heaven's sakes, why not let it be like gender and age, where the Doe gets to, bring forth any research that's possible?
Well, we're looking at two separate determinations. With those particular cases, that research only goes to risk. And the research that exists in this field only addresses risk. There is no research that addresses danger.
But they're saying Hansen has, they keep putting this letter from Hansen, which hasn't been cross-examined, we haven't heard from any other experts, saying, despite the common sense that if you multiply offend against a victim prior to being caught, you're more dangerous because you will multiply offend again if you reoffend. They're saying he may be right, he may be wrong, but that's the only thing we haven't decided, we took this case because it's a constitutional challenge, because you're clearly right, the legislature wants us to do this, but is it a due process violation because you're making a common sense deduction that has been disproved by science? Again, they can't make that argument without an expert and funds and an evidentiary hearing, but that wasn't allowed to happen here.
Two things.
Go ahead.
First, the standard for getting an expert. You have to put forth before the board that you have a particular circumstance, and you have to tell the board what type of expert would address that issue.
Doesn't she do that? She does a very nice job in this affidavit of doing all of that. I'm just looking at, 78 in volume 2 on. She talks about Hansen. She talks about the need for this. I just don't see how we can ignore this.
yeah.
I'm going to separate it again. I'm sorry.
Go ahead. I don't mean to lump things together.
When you delve into the letter, even though it wasn't part of this record, when you delve into the letter that Hansen has written, it only addressed risk. He himself says in that letter,
That he says at the end of the thing that,
he says in the letter,
read the last sentence of that.
I'm sorry?
Read the last sentence of that. Doesn't he use the word risk and danger?
In the very last sentence, he says, in summary, the available research indicates that being arrested and then reoffending is a valid indicator of increased risk. Having more than one sex offense in a cluster of index offenses do not indicate increased risk to reoffend, sexually reoffend.
Okay.
So
There's more to the affidavit we've seen where he talks about danger as well as reoffense. He distinguishes the science on reoffense from the danger point. But again, I may be misremembering. I have it right in front of me.
There's also a related issue, and that is the appellate review. Without any data underlying what the risk of dangerousness, and you could say that it's based on common sense, how are we supposed to do this, the substantial evidence review if we don't have any underlying data which he's asking for, or asking for the opportunity to get?
Okay, so when you look at, and I keep separating out risk and danger, because what you have is research on risk.
Sure.
None of the research addresses danger. When you look at the overall determination of danger by a hearing examiner, they're not solely looking at common sense based on repetitive conduct. They're looking at overall what factors apply. And here, as the court has indicated, factor 3, the statutory high-risk factor, applies with increased rate, as do 2 other factors that were applied with minimal rate. And then you have factor 37 that is talking only on the dangerousness aspect, is only talking about the repetitive conduct, right? If you have a person that has repetitively or multiple times sexually assault a child, a prepubescent child, where there are indications that the child has suffered at least 3 times, as described by the child, one can draw a reasonable inference that that child has suffered more than once under his sexual assaults. So when we're talking about common sense, we're talking about, we could talk about the reasonable inferences that you can draw from that evidence that's actually in the record. There is,
I guess I'm not really focused, or at least I wasn't
On the
focused
victim.
I wasn't focused on whether or not the examiner could apply common sense, but more on the failure to allow the sex offender to even try to put forward any evidence, expert evidence, that would debunk the common sense notion.
well, usually, again, when you have these cases, you have an offender put forth some kind of basis that they're asking for the expert. For instance, if they were to say, we want to present Dr. Hansen, who is going to make a testimony that this particular
So you have to have the evidence before you get the funds to present the evidence. That's
not evidence, but normally you have to proffer something that gives the hearing examiner authority underneath under the regulations to grant that expert funds.
If the board does the board have the burden of proof?
Absolutely.
Okay, so board has a burden of proof, and in order to use the history of repetitive behavior here to support risk, an elevation of dangerousness, and I take it you're not disputing that there's no empirical research to support that, correct?
Correct.
Okay, so it essentially is a black box as to how it's going to support that finding, except that the examiner uses common sense to supply the rationale. It seems to me that in those circumstances where there's no underlying data and SORB has the burden of proof, that if we were to allow common sense to bridge that gap, we're opening the door to arbitrary decision making. And that's my concern.
Well, to address that concern, again, I would indicate that when we talk about common sense, we're talking about the hearing examiner and the expertise that they're imbued upon. Obviously, there is no research on dangerousness. So what you look to is what's already in the record to make that determination. And that's what the hearing examiner did here. You have the statute that only indicates that the hearing examiner can take into account the nature, the number of the aspects of the sex offense. And that's exactly what the hearing examiner does here. Where there is no research on the matter, again, the board is statutorily mandated to make this determination. So if someone punches you in the face, for example, you could certainly make, it's a common sense determination that that's a violent act. No, one does not need research to support that, to draw that determination.
This is different though, because this inquiry is, were this person to reoffend, are they dangerous? And so it's predictive. You know, I get the punch in the face thing, right? So that's a direct call. But here, we're asking about this hypothetical, you know, and then I get the position that we look to see how bad they offended when they did the index offense, to see how dangerous they are to the public. I get that. But then we have this, and I have it in front of me, this opinion by Hansen, who was cited 99 times in the SORB's own regulations, and he says there's no correlation whatsoever to dangerousness.
Well, I think, again, I would defer to that because as I look through his letter, the letter that was written, most of it will address risk. It talks about repetitive conduct with the correlation with risk. He himself indicates there is no research that he knows.
Right. No, that's right, and I think that's the problem.
So even him,
right,
the expert that we all rely upon, cannot come before.
But how does
then that's the problem for you folks.
Right, that's a problem for you because you've got the burden of proof.
We have the burden of proof, but we're looking at dangerousness. We're not looking at risk.
Yeah, but if you're saying Hansen doesn't have anything to suggest that this is all some predictor of dangerousness and that this is resting on common sense, isn't that a problem for you?
I wouldn't say that because, again, when you...
Well, let me say this.
Okay.
It may not necessarily, you may not agree that it's a problem, but when you have a person looking for funds to maybe they're wrong. Maybe they go out and get an expert and the expert says, no, there is a correlation or there is some, but the fact that they asked for this, Hansen says, I'm not aware of anything. Isn't that an abuse of discretion, not giving the funds to go out and try to get this expert or try to find whether or not?
I wouldn't argue that it is an abuse of discretion because, again, even though Hansen indicates that there is no research on the matter, there is nothing that mandates the board to first have research in order to take something into consideration.
No, but they're saying there's the issue we asked to be heard on is there a constitutional due process violation of relying on common sense that may not have any support in the science? That's the issue. And let me read you paragraphs 26 and 27 in her request for this. For this reason, the petitioner seeks to hire a psychiatrist or psychologist with an expertise in sex offender risk assessment and assessments regarding degree of dangerousness, quote, in the event of reoffense. Then we got the up-to-date research. She asked for an expert to provide up-to-date research on the risk to reoffend based on repetitive behavior where there is no evidence. And then the up-to-date research regarding repetitive sexual behavior where there is no evidence of prior sex offenses or compulsive behavior, and an offender's degree of dangerousness in the event of reoffense. It's just, she seems to be probing what we're not sure of and asking for an expert.
She may be probing, but unless you, again, when one comes to the board for expert funds, and I see that we passed time.
Well, only because it sounds like we're covering the same stuff.
Okay.
So we're going to you have a concluding sentence.
Yes. I would just again reiterate that the statute, the law, has not made it a prerequisite in order to determine dangerousness to be supported by empirical research. And here you have a situation where there is no empirical research on this point. However, you have the board statutorily mandated to consider it. So the board uses the information that is within the record to come to that determination. And certainly with regards to due process, it's available for judicial review, and a court can certainly indicate that the board, in coming to that determination based on the evidence in the record, has abused their discretion. And if there's nothing further, I would rest on my memo and ask that you uphold the decision.